Hello everyone. Today I'm going to deliver a detailed and important information about the law that governs partnership in the Partnership Act 1961 in Malaysia. By the end of this discussion, you will be able to understand and perceive the meaning and nature of partnership, the lawful resolution of partnership and partnership agreements, the characteristics of partnership, the types and rights of partners, the obligations of a partner, whether a minor can become a partner to an adult or not, liability of a partner and the relation of partners to one another and outsiders, and finally, the dissolution of partnership. What is meant by partnership? It is important to determine a partnership between parties since the formation of it entails certain obligations and liabilities for the partners. Section 3 of Clause 1 of the Partnership Act 1961 defines partnership as the relation which subsists between persons carrying on a business in common with a view of profit. Partnership, however, does not include clubs, societies, mutual benefit organizations, and building societies. In Section 3 of Clause 2 of the Partnership Act 1961 states that no person can be a partner himself, and at least two or more persons are required to form a partnership. The nature of partnership. There are several forms of business that are generally being conducted out in Malaysia. One of the most conventional types of businesses are partnerships. As we know in Malaysia, the law that governs partnership is the Partnership Act 1961. The act is similar and related to the English Partnership Act 1890, and in Section 47 of Clause 1 of the Partnership Act 1961 provides for the application of rules of equity and common law in partnership so long as they are not inconsistent and unreliable with the express provisions of the Act. In formation of a partnership, the aspects of a valid contract including consideration, competency, free consent, lawful purpose must be present. In addition, the relation between partners concerning rights and duties will usually be contained in an agreement or defined by the Partnership Act 1961. What is the lawful purpose of partnership? A partnership should be formed for a legal objective or a purpose. A partnership is said to be illegal when it is established with the intention to carry and conduct out business activities against the law. Under the Section 47 of Clause 2 of the Partnership Act 1961, a partnership is also judged and considered as illegal if the number of partners exceeds to 20 persons. Partnership agreements. A partnership agreement may possibly be in a way of verbal or written agreement. The partners may have partnership agreements in writing, usually known as articles of partnership, which provides for particulars of the firm and the terms of the partnership. In absence of a partnership agreement, the provisions and terms of the Partnership Act 1961 will be relevant and applicable to the partners. For mutual rights and duties of partners, they may be adopted by the partners' permission as provided under Section 21 of the Partnership Act 1961. Next are the characteristics of partnership. To explore partnership in detail, it is worthwhile exploring the characteristics as revealed by the definitions. First one, the relationship which subsists is one contract. So which means a partnership agreement has to be a contract. To form a partnership, there must be a minimum of two persons. Therefore, there is usually an agreement to be made by the parties which lay down certain terms and conditions relating to the partnership business and duties and responsibilities of the partners involved. This agreement will be binding upon every partner and enforceable in law. Number 2. Parties must be carrying on a business, and for this reason, a group of people who run a social club would not be a partnership. In Section 2 of the Partnership Act 1961 defines business as includes every trade, occupation, or profession. Thus, the persons must have an agreement to have a business in common. which means there must be some mutuality of rights, interests, and obligations, and the agreement must be for a business purpose. The last one, there must be a view of making profit. As provided in section 4, B and C, the partners agree to carry on business for profit. Thus, if a person is excluded from sharing any profit in a partnership, then he is not a partner. Similarly, the relationship between persons to do voluntary or welfare works is not a partnership. Stated are few illustrations of case related to each characteristics for your reference. The relation between members of a company or association which is registered as a company under the Companies Act 1965 or a cooperative society under any written law relating to cooperative societies, or the relation between members of a company or association which is formed or incorporated by or in pursuance of any other law having effect in Malaysia or letters patent, Royal Charter or Act of Parliament of the UK. Therefore, Section 3 of Clause 2 of the Partnership Act 1961 excludes the following list from the classification of partnership. The type of partners can be described as following. A nominal partner. A nominal partner is one who offers his name and repute to the firm. He does not invest in business and he does not get share in profits, but he is regarded as partner in the eye of law and is liable to the outsiders for the debts of the firm. An active partner is a partner who energetically participates in the management of the business and is recognized to the world as a partner. A dormant partner, or sometimes called as the sleeping partner, is the partner who takes no effective part in the management but is nevertheless liable as a partner. A partner in profits is a partner who shares the profits of the firm but not liable for the losses, but still equally liable as other partners to the outsiders or third parties. A senior partner is a partner who has made further investments in the business and obtains more profit. A junior partner is a partner who has a tiny investment in the business and obtains a minimal share in the profits. Under the Partnership Act 1961, the rights of the partners are as following. Partners have all the rights to take part in business, inspect books, share profits like identifying the profits, cash flow statements, balance sheets, income statements, inspecting stock inventory, and etc. Also, as a business partner, we are having a right to give consent and right to retire, which means the consent of other partners or according to the partnership contract or by giving notice to all employers. The duties or obligations of a partner. As a partner, we have a responsibility or an involvement towards the firm or business. It is the duty of every partner to carry on the business of the firm for the common advantage of the partners must be faithful and just towards the firm and towards the other partners in their actions, specifically in maintaining the firm's bank accounts. Every partner is required to reimburse the firm for any loss caused to it by a partner's conduct like fraud or falsification. A partner is required not to transfer his shares without the permission of other partners. The question here is whether a child can be a partner to an adult or not. The answer is yes. A minor is capable of becoming a partner to an adult and is acceptable in partnership. In the law it states sui juris, which means any member is capable of becoming a partner. This includes a child also. However, a child cannot be accountable and responsible for any contractual for the firm's debts and liabilities. An illustration has been explained for your reference. Liability of the partner. Every partner is liable jointly with the other partners for all debts and obligations of the firm incurred while he was a partner. In Malaysia, a partner's liability in contract is governed by 2 of the Partnership Act 1961. According to that, a partner's liability for debts and obligations if the firm incurred while he is a partner. This means that there is only one cause of action, and if it is exhausted, no further action against any member of the firm can be commenced. Whatever the contract in the firm will allow everyone jointly liable if the contract is breached, and provided that the contract is incurred while he was still a partner. If he left the firm and after that he is creating the contract, then all the people in the firm won't be responsible. As mentioned in Section 12 of the Partnership Act, severally liable for torts committed by co-partner while both members are of the firm. Tort is the civil wrong which is caused under civil law, example defamation, negligence, and death. Under Section 13 of A of the Partnership Act 1961, a partner is liable for his co-partner's misapplication of money received by the co-partner in the course of his apparent authority. Also, in the partner's liability, a partner is not jointly liable for criminal act done by partner. This is applicable if the person has agreed that he committed the murder and feel guilty. This is only liable in point 1, 2, and 3 and not in 4. An illustration has been stated for your reference. The relationship between partners. The association between partners may be controlled by a partnership agreement made by the partners which outlines the rights and duties and other terms relating to business management, distribution of capital, and profits of each other. The provisions contained in Part 4, Section 21 to 33 of the Partnership Act 1961 will only apply where partners do not provide the terms of partnership in their partnership agreement. Section 21 of the Partnership Act 1961 provides that the mutual rights and duties of partners, whether discovered by agreement or defined by the Act, may be different by the approval of all partners, and such approval may be either expressed or assumed from a course of dealing. Above all, the theory of extreme good faith towards each other is understood in the partnership agreement. The relation of partners to one another. Mutual rights and duties of partners as explained in the Section 26. The obligations of partners to act in utmost good faith as explained in Section 30, 31, and 32. All partners are permitted to share equally in the capital and profits of the business and must contribute equally to losses whether of capital or otherwise. The firm must reimburse every partner in respect of payments made and personal liabilities sustained by him. No partner is entitled to interest on capital before the ascertainment of profits. Every partner may take part in the management of business. No partner is entitled to remuneration for acting in the business, even if the partners have worked unequally. Also, no person may be introduced as a partner without approval of existing partners. At last, the partnership books are to be kept and the place of business of the partnership. The relationship of partners to outsiders. The agency principle is significant in the relationship of partners to outsiders because a partner is an agent for the firm. Whether a partner carries out activities within the ordinary course of partnership because his act will bind the other partners so long as he has the authority to act and does not act beyond the authority given. Also, a partner has an authority to bind the firm if he carries out the partnership business within the scope of authority. In the Section 7 of the Partnership Act 1961 provides that every partner is an agent for the firm and other partners for the purpose of the business of partnership. This means any act done by a partner in the course of partnership business binds the firm and other partners unless the partner has no authority or is unauthorized to act for the firm and a third party. Relevant illustrations have been stated for your reference. Next is the dissolution of partnership. A firm ceases to exist when it is dissolved or terminated. This means all the firm's business cease to operate upon dissolution of a partnership except the obligations of the partners to continue to do the necessaries for purpose of dissolution and completing the incomplete activities. Partners are at liability to fix the duration of the partnership where no fixed term has been agreed upon for the duration of the partnership, and any partner may terminate the partnership at any time on giving notice of his intention to do so to all the other partners, as explained in Section 28 of the Clause 1. There are several ways in which a partnership may be terminated or dissolved. We are going to look for more details on this below. A partnership can be dissoluted by expiration of term or notice, which means agreement as mentioned in Section 34. A partnership is dissolved by the expiration of the term fixed or by the termination of an adventure or undertaking or by any partner giving notice to the other of his intention to dissolve the partnership. Also mentioned in section 35, every partnership is dissolved by the death or bankruptcy of any partner. A partnership may be also dissolved if any partner suffers his share of partnership property to be charged under this act. A partnership may also be dissolved if any partner suffers his share of the partnership property to be charged under this act for his separate debt. As mentioned in section 36, a partnership is dissolved by the happening of any event which makes it unlawful for the business of the firm to be carried on for the members of the firm to carry it on a partnership. As mentioned in the section 37 of A, by court orders when a partner is lunatic or of permanently unsound-minded, which means he is mentally not well. As mentioned in section 37b, when a partner becomes permanently incapable of performing his part in the partnership contract. Also mentioned in section 37c, when a partner has been guilty of any conduct which affect prejudicially the carrying on of the business. As mentioned in section 37d, when a partner willfully or persistently commits a breach of the partnership agreement or conducts himself in a manner that this is not reasonably practicable for the other partners to carry on the business in partnership with him. Also mentioned in section 37e, when the partnership business can be only carried on at a loss. At last, as mentioned in section 37f, whenever any circumstances arise that renders if just and equitable, if the opinion or the court for the partnership has to be dissolved.